What every Social Security disability applicant needs to know about meeting the medical and vocational criteria of steps 4 and 5 of the 5-step sequential evaluation. If you don't meet a listing, and many cases don't, you have to show at step 4 that you can't go back to the lightest job you held in the 15 years before you became disabled, and at step 5 that there isn't any other work that you could do in the mythical national economy based on your age, your education, your skills, and your residual functional capacity. As I said, the Social Security Administration is going to be using medical and vocational criteria. And the first thing the Social Security Administration is going to try to determine is, what is your residual functional capacity? In other words, what is it that you can do despite your arthritis? The Social Security Administration is going to look at your medical records at the initial application stage and the request for reconsideration stage, and they'll try to determine whether you can do sedentary work, light work, medium work, or heavy work. If the Social Security folks can't figure it out, they will send your file to a medical consultant. And guess what? The medical consultant will opine that you can do some level of work that will result in a claims denial. The reality is that the lower your residual functional capacity is, the more likely it is you'll get your benefits. And I think it's crucial that you have a doctor fill out a residual functional capacity form. Now, the Social Security Administration is going to tell you about that form, but the form will explain how far you can walk, how long you can stand and sit at one time and for an 8-hour workday, how much and how often you can lift, stoop, squat, or bend during an 8-hour day, whether you have to alternate sitting and standing, whether you've got problems with your hands and your fingers, whether or not you have problems with your hips, knees, or ankles that require you to use a crutch, a cane, even a wheelchair, whether you have good days and bad days, how many you have a week, how many days per month you would miss from work, and whether or not you have psychological problems that would interfere with your ability to work. This isn't a complete laundry list of all the questions on a residual functional capacity form, but it's crucial that you have this information, because ultimately if you have to go to trial, the judge will determine your residual functional capacity. And what's crucial is that the other part of this equation is the vocational aspects of the case. If you have to try this case, the judge is going to be questioning you, determining your residual functional capacity, and then turning to the one other person who's in that hearing room with you, a vocational evaluator. A vocational evaluator knows all about the world of work. And so what will happen is the judge will form a hypothetical. And the hypothetical might be something like this. Mr. and Mrs. VE, I want you to assume that this person, just like the person here at this hearing, can sit for 6 hours out of an 8-hour day, stand for 2 hours, lift up to 10 pounds. Now, could this hypothetical mythical person, just like this person here, go back to the lightest physically demanding job they held in the 15 years before they became disabled? If that vocational evaluator says yes, you lose. And if the judge doesn't ask another question, you've lost your claim. Now, if the judge does ask the next question, and that is there any other work in the national economy that you could do in view of your age, education, transferable skills, and that VE lists 3 jobs, like ticket taker, or a person who works watching surveillance system monitor, who calls 911 if somebody breaks into a house, or can roll silverware all day, or can address envelopes all day, you're going to lose. And if the judge doesn't ask any more questions, you lose. Look, statistics show that those who have representation at all stages of a Social Security claim are more likely to get their benefits. Call me today at 727-894-3188 for a complimentary consultation. I can explain to you the 5-step sequential evaluation, the claims process, and how we can work as a team to get you the Social Security disability benefits you deserve. Make the call. Cavey Law.